Supreme Court briefing on the upcoming term. My name is Glenn Lamby. I'm Chief Counsel of the Foundation's Legal Studies Division. Our focus today is going to be the focus of the Foundation, and it has been for 41 years, on cases that affect the free enterprise system, regulation, litigation, basic constitutional rights in the business context. In addition to filing briefs in the Supreme Court and the lower federal courts and state courts as well, we're a very active educator through our Legal Studies Division, put out publications on a wide range of issues, and also we put on programs such as this and webinars, and we have a blog, the WLF Legal Pulse. If you're online, I encourage you to take a look at that. I'm going to introduce our moderator today, Jay Stevens, who, for our purposes, we're very proud to have him as our chairman of our Legal Policy Advisory Board. He has had an incredibly distinguished career both in the public and the private sector. He's currently counsel to Kirkland & Ellis. Previous to that, he was general counsel, corporate secretary at Raytheon. Prior to that, he was the Associate Attorney General of the United States, U.S. Attorney for the District of Columbia, and Deputy Counsel to the President of the United States. He was also at Honeywell as well, and at a private law firm. So I'll give the podium over to Jay, and thank you for coming today.
Thank you very much, Glenn. It's a pleasure to be here and to moderate the panel, which should be a fascinating discussion. We're very fortunate to have two distinguished advocates, practitioners before the Supreme Court. And I think, folks, that'll give you a really interesting insight into some of the issues that WLF has been concerned about and interested in, and areas where we've participated in litigation through amicus briefs. And also to have a discussion about some of the issues and trends that the Supreme Court seems to be grappling with or facing, and I think it'll be an interesting discussion. We'll have time for questions, so if you have questions online or in the audience here, please be sure you get online and get your question asked, and we'll go from there. So I'm going to start. Our first speaker will be Pratik Shah. Pratik is a partner at Akin Gump, Strauss & Hoyer here in Washington, D.C. He's co-lead of the Supreme Court and appellate practice there. He's argued a number of cases, in fact, I think over 15 cases before the United States Supreme Court, so I don't think we could call him a rookie. I think we have to call him a pretty distinguished, experienced practitioner before the court. Prior to working at Akin Gump, Pratik had worked for 5 years in the Solicitor General's Office of the United States Department of Justice. He clerked on the United States Supreme Court for Justice Stephen Breyer, and prior to that he had clerked for William Fletcher on the United States Court of Appeals for the Ninth Circuit. So Pratik brings a wealth of experience to his comments and insights today. Joining us also is Lisa Blatt. Lisa is a partner at Williams & Conley. She is chair of the Supreme Court and appellate practice there. She's argued, I was going to say most of the cases before the Supreme Court, she's argued 37 cases before the United States Supreme Court, which is a remarkable set of experiences. She is currently has cases before the Supreme Court for this term, and I would also say she had the pleasure of clerking, I guess I would say, for RBG before RBG was RBG. She clerked for Judge Ginsburg when she was on the D.C. Court of D.C. Circuit. Lisa also had a tremendous experience at the Solicitor General's Office at the Department of Justice. She worked there for 13 years, a lot of experience. She worked as well at Service and Government at the Department of Energy. We're pleased to note that Lisa joined our Legal Policy Advisory Board here at the Washington Legal Foundation this past spring and summer. So welcome. Pratik will start out with some comments and commentary about some of the cases that are of interest to the clientele and the constituency of the Washington Legal Foundation and things that he's engaged with. Then Lisa will have some comments perhaps on some cases as well as some of the issues. We will then have questions from the audience, and I have some questions that I would like to follow up on regarding some of the thematic questions that the Supreme Court may be grappling with over the next couple of years. So, Pratik, the floor is yours.
Thank you very much. I appreciate the introduction. Before I dive into some of the specific cases, I thought I'd offer a few broader thoughts on questions or themes carrying over from last term into this term. The first is who will emerge as the swing, or perhaps more precisely median vote on this newly composed court. I think many of us had been betting on the Chief Justice to fill that role, relying on his strong institutionalist bent, as kind of a moderating influence. Perhaps that will still prove true, but I'm somewhat less sure that's clearly going to be the case. I think the picture may in fact be more nuanced than that, without any single justice sort of filling that role, at least in any way resembling the way that Justice O'Connor or Justice Kennedy after her filled that role. Obviously, it's only been 1 year, and so you can't draw any firm conclusions, but I think the data from last term at least raised some interesting questions. We know that Justice Kavanaugh, not the Chief Justice, was the justice most often in the majority last term, and curiously, perhaps more curiously, Justice Kavanaugh voted as frequently with Justices Breyer and Kagan as he did with Justice Gorsuch. Speaking of Justice Gorsuch, I think in further complicating the picture is the fact that he was the justice most often in the majority when it came to 5-4 cases. Nobody would describe Justice Gorsuch as a median justice, I don't think, but he has shown the tendency to swing in certain types of cases, at least. We know the Indian law cases are one area. There were the 2 treaty construction cases last term in which he voted with the more liberal justices. Certain federal criminal law cases, not unlike his predecessor, Justice Scalia, who had somewhat of a maverick streak when it came to those cases. I think there's going to be a few cases this term that may shed some light further into Justice Gorsuch's voting patterns in these sort of cases. There's an Armed Career Criminal Act case on the determination of when a predicate state law offense qualifies as a quote, serious drug offense that would trigger a federal minimum sentence of 15 years for a felon in possession conviction. I feel like there's been at least one of these cases every year since Lisa and I were in the SG's office together. But this is the sort of case where I think you could see some mixed alignments and not the traditional 5-4, with Justice Gorsuch playing a role. There's the Bridgegate case, that's Kelly v. United States, where essentially the issue is whether an public official can commit wire fraud for producing a reason for an otherwise permissible governmental action that doesn't map onto the true motivations, right? You give a public policy, a legitimate public policy rationale, but you really have ulterior political or improper motivations for doing it. Can that be wire fraud? And as I gather, the theory of that is, well, you wouldn't have undertaken the action without giving the false reason for it, and therefore you're defrauding the government by deploying government employee time to execute that policy. I think that's certainly one where it may not be a traditional lineup. In fact, not only Justice Gorsuch, but there may be other justices voting against the government in that sort of pretty broad theory. I mean, you can think about how that theory would play out in the census case from last term, where even the Chief Justice called out the Secretary's action as contrived. That is not a legitimate, his true motivation was not the public policy rationale, and I think under the Third Circuit's rationale in the Bridgegate case, maybe that would lend itself to a wire fraud prosecution. That does not seem quite right. And so I think that's another one of those cases. There's a case that Lisa is involved in, Sharp v. Murphy. Of course, Justice Gorsuch is recused in that case. But that's another question where the court is going to have to figure out to come to some answer with an 8-justice court. That's a case about whether the state has authority, and Lisa may offer a different characterization of the case, but a state's authority to prosecute crimes by tribal members within a territory that was set aside for their reservation in the 19th century, never clearly repealed, but now covers a good part of Oklahoma, evidently, so there's a lot of, I think, practical concerns there weighed against the concern of creating bad law in the tribal space. So I think there's going to be a lot of cases this term that shed greater clarity as the justices kind of find their evolving role. To the extent there is a new middle at all, I think we'll get some more data on that. I'm not going to talk about these cases today. I think Lisa may touch on a few of them, but in particular, some of the big ticket cases are going to obviously shed a lot more light on where the justices are going to fall on these kind of traditional 5-4-ish type issues, the Title VII cases. I think Lisa's going to talk a little bit about the DACA case, obviously, which everyone knows about, the Montana Free Exercise case. That's kind of the follow-on to Trinity, Lutheran, and Locke v. Davie. And that's going to be the question of whether the Chief Justice really meant it when he said that Trinity Lutheran, the funding that you have to fund organizations really just limited to religious and non-religious equally is really just limited to playground resurfacing. Here it's in the educational context. There's a County of Maui EPA case. Usually those sort of Clean Water Act cases, and this is about whether a permit is necessary when someone discharges into groundwater that goes to a navigable water rather than the navigable water directly. Those are traditionally 5-4 type cases, kind of how that's going to come out. So I think all of these will give us some more data about some of the things that we learned from last term. Or maybe they won't. Maybe they'll all just be 5-4 on the same lines that we all expect. The other question, I think, is the emergence of stare decisis as kind of the battleground for a court. It was obviously a strong undercurrent last term. I think it could turn into a bit of a tsunami this term, especially if the court grants in the Louisiana abortion case. The lines here are fairly well drawn on stare decisis, at least. We know Justices Gorsuch and Thomas from last term have basically said, look, if a case is wrong, let's call it wrong and overrule it. Justices Breyer and Kagan have dug in on stare decisis, offering pretty emphatic defenses. There was Justice Breyer's not so subtle citation to Casey in his dissent when the court overruled kind of a low stakes state sovereign immunity issue in the Hyatt case, but obviously presaging the Louisiana case, which I think is being conferenced or was conferenced yesterday. And that, of course, it raises the question of whether the court is going to overrule Whole Women's Health about restrictions on abortion clinics without admitting privileges, or whether they come up with some sort of distinction. It's going to raise questions about whether how strong the Chief Justice's institutionalist bent is in this sort of case. Obviously, he voted with the liberals on the stay. Does that carry over to the merits? Does he sort of return to his project of chipping away at precedents by distinguishing them? How does Justice Kavanaugh thread the needle between stare decisis and his view of the merits? Maybe his stay opinion kind of shed some light there. I think that is going to be a telling case. If I turn, I guess, to a few of the individual cases that may be a little bit more under the radar for this coming term, I'm going to start with the other set of discrimination cases, not the Title VII cases, but the race and age discrimination cases. Both present essentially the same question presented, whether a plaintiff has to prove discrimination by the standard of but-for causation. But-for causation, of course, is the strictest standard for a plaintiff to show. The first one is a case called Comcast v. National Association of African American-Owned Media. And the question presented there is whether a claim of race discrimination under Section 1981 requires but-for causation. 1981 governs contracting, and specifically it guarantees to all persons, quote, the same right to contract as is enjoyed by white citizens. That's the language of the statute. There's a prior Supreme Court decision called Nassar that basically said, at least when you have because of discrimination language in a statute, it presumptively requires but-for causation. Here, of course, it isn't but-for, it's same right as is enjoyed by white citizens, which there really isn't a case that it interprets a statute using that sort of language. And so the question is, does that fall on the but-for side, or as the plaintiffs wanted some lesser standard like motivating factor? You just have to show it's a factor even if it wasn't a dispositive one. I think more concretely here Comcast allegedly denied an African American owned TV business a contract. So under the but-for standard, essentially the plaintiff would have to show, look, if I weren't a black business, I wouldn't receive the contract. The district court said you don't meet that standard, dismiss the case. The plaintiff argues, and the Ninth Circuit agreed, that all you have to show is a motivating factor and the case should go on. I think the briefing here, one thing that jumped out is it kind of shows how far we are. This is nothing new, I think, as Justice Kagan said in tribute to Justice Scalia, we're all textualists now. Here's a case where, race discrimination cases were not argued like this even, 15 years ago. But it's all about the text of the statute, which at least to me doesn't kind of jump out as a clear answer as to the standard of causation when it says the same right is enjoyed by white citizens. But you have the plaintiff arguing that if race is a motivating factor, they're not getting the same right as a white person. You have the defendant arguing that look, if you come to the same decision, ultimately, then they're getting the same right as the white person. I don't really know the answer as a textualist matter, but I think you're going to, or this is one of those cases that I do think will be revealing about how the justices approach kind of statutory interpretation in this court in a kind of fraught area. The other one is an age discrimination case. Again, as I mentioned, same question presented. Do you have but-for causation for plaintiffs? That's under the age discrimination statute. And it's whether the ADEA provision that applies to federal employees as opposed to private employees, this is only about federal employees, requires but-for causation. There, the text, I think, is kind of helpful and kind of points you in a direction. It says, personnel actions must be, quote, made free from any discrimination based on age. And then it's in contrast to the parallel private employee provision, which uses the traditional because of language. And so here, I think the plaintiffs actually have a pretty good textual argument. The literal terms, made free from any discrimination, seem broader than just but-for causation, and particularly, of course, in contrast to that private employee provision, I think this is going to be a tough case for the government. Something an institutionalist might ask is, does the court kind of ruling for the plaintiffs in these traditional forms of discrimination cases help the court's perception when it rules on the Title VII cases? If it were to go the other direction, is that a factor at all? Do they get announced the same day? I don't know. It's just something that I think may be a subtle undercurrent when they get to the bigger cases that Lisa's going to be talking a bit about. In the theme of other cases, just like the other discrimination cases, I'll say a few words about the other Affordable Care Act case. This is not the big one percolating in the Fifth Circuit, challenging the validity of the Affordable Care Act. This is on an issue, it's a trio of cases actually, called MODA, Land of Lincoln, Maine Community Health Options. This has a more discrete issue, but has implications for any business doing partnerships or entering into contracts or agreements or programs with the federal government. And it involves government payment obligation to health insurers under what was called the Risk Corridors Program. This was part of the Affordable Care Act, and it was meant to help the Affordable Care Act get off the ground, and essentially required the federal government to reimburse insurers that participated in the initial health insurance exchanges for losses that occurred when the costs exceeded premiums. It was essentially to limit their downside if they participated. No one knew how this was all going to play out. So they said, look, if you participate and it turns out that you get a flood of unhealthy people here and your costs exceed your premiums, we'll reimburse you at least a part of your losses under some formula. It also limited the upside of the insurers in that if they made more money, if they took in more premiums than they paid out, they would have to pay a portion of that back to the government. And obviously this was all designed to encourage health insurers to participate and set lower premiums than they might otherwise do. Turns out that the program was quite necessary. There was about a $12 billion shortfall in reimbursements even after you paid out the money that the government took in over the first 3 years of the operation of the exchanges, and that was the time period of the Risk Corridors Program. Congress apparently didn't like that big amount, and so they passed some appropriations riders that essentially restricted the source of funding to make the Risk Corridor payments. So the question presented is, can Congress repeal what everyone agreed was sort of a categorical payment obligation in that indirect manner? Whereas the petition puts it, can Congress promise boldly but renege obscurely? And so everyone agrees here that Congress can repeal payment obligations. Obviously, Congress can change the law, but they have to do it explicitly, and that just comes from the presumption against implicit repeals. And so really the question here is, what Congress did good enough? The Federal Circuit said yes, it was, although unhelpfully to the federal government, it relied on legislative history underlying the after-the-fact appropriations rider, which did not help the government's cause in trying to dodge cert. The court granted cert, which I think is not a good sign for the federal government, and I should disclose here that I represent AHIP in this case. But look, you have a decision from the Federal Circuit, which doesn't have the greatest track record in recent years in front of the Supreme Court. You have a transitional program that the court might otherwise have let go if it thought everything was fine, since it's not going to recur. It ended in 2016. You have the government winning, so it wasn't like an SG cert petition or anything. And you have the lower court relying on legislative history. So I think signals point favorably for the challengers in that case. I have a few minutes left. I'm just going to talk about a couple pending cert petitions that I think might be of interest. And I don't know if they'll be granted, but I think if they are granted, there's certainly ones that could be in the 5-4 territory. So worth mentioning. The first one is one that Lisa did. So she can't talk about it, but I can. I did an amicus for Retail Litigation Center supporting her petition, so I might be a little biased as well. It's called Domino's Pizza v. Robles. It's another discrimination case, but this one under the Americans with Disabilities Act. And essentially the question is whether the ADA imposes independent accessibility requirements on websites and apps that might be linked to a public accommodation. The ADA, of course, regulates places of public accommodation. That's a statutory term. So the question is, does that even apply to websites and apps at all? And if so, how do you comply with that sort of requirement? There are virtually no DOJ regulations on this. So all there is that governs this question, obviously the ADA was enacted before you had websites and all that stuff. You just have a series of private party guidelines that courts have used to monitor whether industry is in compliance. Those, according to industry, are pretty complex and manipulable. So it turns out when you run these private party guidelines or websites that lets you do this, even the Supreme Court's own website produces all sorts of non-compliance errors. The facts here, Domino's offers, according to Lisa's brief, 15 different ways to order a pizza. The visually impaired plaintiff in this case tried to use one of those ways, which is an app, to order the pizza, but received screen reader errors when they were trying to use the app, so could not successfully place an order. The Ninth Circuit held that that app, because it's used to access the public accommodation here, Domino's Pizza, it violates the ADA by not making it fully accessible. Domino's argues, among other things, that that compliance must be judged as to accessibility as a whole. When you look at all of the methods, not just the web or app, you look at all 15 ways, and the 14 other ways provide enough access. This case has, not this case in particular, this issue has resulted in a proliferation of litigation in the last 2 years in particular, targeting websites of art galleries, obviously, that could produce screen reader errors. Universities, even Beyonce has been subject to one of these suits, and it's just generated general confusion. So I think that's one to keep an eye on. I think it's conference yesterday, big conference.
Yeah.
The other one is probably one that's not on your radar yet. It's one that was just filed a few days ago. It's called Doe v. Nestle. It's an alien tort statute case. This involves a long-running, I think it was filed 14 years ago, an ATS suit alleging child slavery in the Ivory Coast by farmers that grow cocoa under contract with defendant corporations that produce chocolate. They allege that the defendant corporations had knowledge and provided other assistance to these farmers that were growing the cocoa. So they sue all these global corporations. Of course, we are now in a post-Kiobel and a post-Jesner world, where you cannot sue for purely extraterritorial conduct, you cannot sue foreign corporations. So essentially that requires allegations against a U.S. subsidiary corporation, and it requires aiding and abetting allegations that happened actually in the U.S. that might have aided and abetted the conduct happening overseas. The Ninth Circuit, the district court dismissed applying principles from Kia-Bell and Jesner and saying this complaint doesn't allege actual extraterritorial conduct by the U.S. companies. It names a bunch of global corporations and mixes in the U.S. companies, and all it really alleges is lack of corporate oversight, which is not enough. But the Ninth Circuit vacated and remanded and said, look, the plaintiff should have another chance to replead this case and provide more specific allegations than they have to date. The cert petition essentially says, look, the Ninth Circuit apparently hasn't got the memo on Kia-Bell and Jesner from the Supreme Court, and so the Supreme Court has to step in again and provide further clarity or finish the job that it has started. I think there's very little doubt how the Supreme Court would rule if it granted cert. Obviously, you have a different court than decided Kia-Bell and Jesner, but Justice Kavanaugh, when he was on the DC Circuit, and this is before either Kia-Bell or Jesner, it was a case involving Exxon, he actually advocated for the same categorical limitations that the Supreme Court enacted in Kia-Bell and Jesner, and in fact he would have gone farther and wiped out any corporate liability at all in that opinion. And so I think if the court grants, it's not a good thing for the plaintiffs. I think the real question is, does the Supreme Court feel it needs to weigh in again and send another message? So I'll stop there and let Lisa take over.
Okay.
Thank you.
Thank you, Pratik. Lisa?
Thank you, Pratik. I could listen to him all hour. I thought he did a great job of summarizing the themes. I'll just add a couple things on last term, but I just wholeheartedly agree with the way Pratik framed it. It was a bizarre and strange and inexplicable term, the way the votes matched up. I hadn't seen anything like that in a long time. I think it shows that the conservatives are divided in the way that the liberals aren't. Whether that will continue, I think, is anyone's guess. But I do think the biggest reason is something Pratik touched upon, and we seem to love statistics, but I think these statistics are telling. Justices Sotomayor and Elena Kagan, they voted their first term together 96.22%. So they agreed basically on virtually everything. But Justices Kavanaugh and Gorsuch only agreed 70% of the time. And Justice Scalia and Justice Kennedy, their first term together, decided 94.5% of the cases in agreement. So I think that it just shows, despite most of the world thinking that Justices Kavanaugh and Justices Gorsuch are just cookie-cutter versions of one another, they went to the same high school, they look like they have the same resume, they're very different justices. And I feel like that is something, as an advocate, I've noticed. Justice Kavanaugh seems quite reticent at oral argument. He's ready, he's just more willing to sort of just listen to the advocates. He does not take a sort of leading role. And I don't necessarily think he's waiting to announce his sort of stamp on the world. I think that this is what we're going to see of Justice Kavanaugh as we go forward. And I really, everything else, I just agree. I just wholeheartedly agree with Pratik on the swing justices. I think to some extent, Justices Roberts and Kavanaugh probably wish that maybe there were one or two more conservative justices on the court so they wouldn't sort of be the center of attention when it comes to Roe. And I think that that's it. I will say one other thing just on stare decisis, because that does seem to be such a emotional issue for the justices. And I just like these two quotes that came out of last term. This is in a case where a case was overruled and Justice Kagan dissented. And this quote is, "Maybe the majority should take the hint. When a theory requires declaring precedent after precedent after precedent wrong, that's a sign the theory itself may be wrong." So there she's trying to say, hello, let's stop overruling cases. And then there's Justice Thomas on the other end in a case where the court didn't overrule a case. That was a double jeopardy case. That was Gamble. And his quote is, proponents of stare decisis tend to invoke it most fervently when the precedent at issue is least defensible. So these are just like caustic statements. And what's interesting about this is there's Justice Ginsburg, who's sort of a maverick in all this because she obviously cares a lot about stare decisis, but she was more than happy to overrule Gamble. So I think she's not as predictable when it comes to stare decisis. And although there were 4 cases last term that were explicitly asking for a case to be overruled, there were 2 other cases where the court just significantly cut back on doctrine, and one was this religion case on the Lemon Test, and another was an Indian treaty case. So there's just a lot going on. All right, I'm going to talk about the sex cases just because they're A, interesting, and B, to me, they reveal a lot about the justices and the way they think and they approach cases. These are well, maybe these are the biggest cases. In my view, these are the biggest cases, although I think the Dreamer case is also a big case in terms of impact. But these are 3 cases. I don't know how to pronounce this. Bostock versus Clayton County. We have a county employee, and then Altitude Express is a skydiver instructor. In these cases, raised the question of whether Title VII extends to sexual orientation. And so the statutory question is if you discriminate against someone because of their sexual orientation, is that, quote, because of sex, which is the statutory phrase, because of sex. The other case involves RG and GR Harris Funeral Homes, and that's a funeral home worker, this raises the question of whether Title VII's ban on discrimination because of sex applies to transgender status. What I like these cases is because you can ask anyone on the street what they think, and their view would be valid. Because of sex, I don't know, what do you think? I think it's just so, I could write an opinion going either way, and it would be a very persuasive opinion. And so this just sort of comes down to how the individual justices are going to see this. The one other wrinkle in because of sex issue is, to me, it's like a debater's argument. You could say, sort of in my view, it's obviously because of sex. Sexual orientation and transgender status are inexorably linked to sex. And you could sort of argue it, if I were a woman and liked a man, I wouldn't be discriminated against, but because I'm a woman and I like a woman, I am, or because I'm a woman and my identity is with the man. That's the employee side, but the employer side is, well, I'm treating men and women exactly equal, and I'm treating male and female transgender people exactly equal. So one of the sort of nuances that the employees are trying to present is this could they sort of pigeonhole this into this Price Waterhouse case saying you can't discriminate based on sexual stereotypes? And that's kind of obvious in the case of the funeral home worker. He was a male at birth, identifying as a female, dressing as a female at work, and he was fired because of that. And the argument is, well, your stereotype is the way a certain man has to dress. The importance of it, 89 amicus briefs were filed in the sexual orientation case, and 64 amicus briefs were filed in the transgender case. That's a ton of amicus briefs. Most are on the side of, actually no, in the sexual orientation case, more were filed on the side of employees. In the transgender case, more briefs were filed on the side of employers. And I think that there's an interesting dynamic between the cases. Transgender, to me, feels like it's obviously because of sex, but I think people perceive that as a harder case because it's sort of foreign to the justices and they don't know where that'll go, but we'll see. But I'm going to go ahead and say it. It just seems that they are going to vote on how they want to come out. Although there's an argument, and I know that this will play big at oral argument, and I'll tell you, I think it's obvious to the employer side of this that Congress was not thinking about sexual orientation and transgender status when it passed Title VII. And so that's a very powerful argument on the side of employers, that this can't be what Congress, and I don't think anyone thinks that Congress passed this statute to protect transgender employees and sexual orientation. And then there's sort of the sort of common sense side of, seriously, you're taking a huge bite out of the statute. when it seems to fit the definition, at least to liberals like myself. All right, so let me get to the, but there, see, I've shown my bias. For separation of powers and, I don't know, these are just like hot topics right now, but appointments clause cases. This case, there are 5 cases on the court's docket involving the PROMESA, but it's the Puerto Rican Oversight Management Economic Stability Act. I may have messed up some of those, but this is when Puerto Rico had a just complete meltdown economically, and because the bankruptcy laws only allow municipalities to file for bankruptcy, Puerto Rico had no way of restructuring its debt. And like a lot of cities, counties, and I guess even states, pension debt has been a big problem. Congress passed this act that set up this oversight board that allowed the restructuring. It was basically a mini bankruptcy law. But the statute provided for the president to appoint all the members, and President Obama did that. The Aurelius, whose name is in, I think, I don't know, 4 out of the 5 cases, is the holder of bonds. They're challenging the constitution and establishment of this board because these are officers of the United States that have to be appointed by the president, and Senate has to consent. And there was no provision for advice and consent by the Senate. There doesn't seem to be much debate that given their sort of statutory role, continuing role and oversight, that they would be officers of the United States. I don't think the parties are, maybe they're not really, maybe they're fighting it, but I don't think that's where the real rub is. The main argument that the government makes, and the board, the Puerto Rican board, and the people supporting the board, is that officers of the United States doesn't apply to Puerto Rico, that this is a territory, and therefore Congress could have done whatever it wants. And then, you know, there are arguments on the other side. I think where the really interesting part, and that just seems a straightforward issue, do you think that the appointments clause command in the Constitution applies to territories? The more interesting question is, and if it does, what do we do if a body that has made a lot of decisions involving a lot of money is improperly constituted? What do you do about that? Does it unwind all of the acts the board took? I guess it was the First Circuit that this came out of, I think held under this de facto officer doctrine. I love the legalese, but basically, you know, they did it, they had the appearance of doing it, so it's, you know, neither here nor there, just sort of leave it alone. And other people are saying, that's sort of like when you're just putting a stamp on maybe a marriage license or a driver's license. This is not for some huge issue involving billions and billions of dollars. So there's a massive amount of briefs on that. It's a huge case involving the money, but the the remedy issue on appointments clause violations, to me feels like it's a practice run for what's coming down the pike. And these are a series of cases I'm going to talk about that aren't on the court's docket, but everyone predicts they will be. And that involves the Consumer Fraud Protection Bureau, and also, I guess, the Fannie Mae, the FH, what is it called? FHFA, I just don't know what it stands for, but. Thank you, Pratik. These are obviously big agencies. The other thing I will say about these appointments clause issues, they're basically, they're fancy names for separation of powers, but what's really going on at the heart of these cases is whether there's sort of a deep state of government bureaucrats controlling our lives, and is there any accountability to the people? So that's what's really going on, but I'm going to talk to you in more fancier terms. So these are government agencies that were set up, but they're set up just with a lone director. So the CFPB has a director, and the FHFA has a director, and the director is removable only for cause. And again, people who care about this stuff are very deep thinkers about separation of powers. Apparently that's problematic because we have a unitary executive branch, and the president should be able to fire and hire anyone at will. That sounds reasonable to me, but there's this case called Humphrey's Executor, which all legal nerds apparently know by heart, that said it was okay to enact for-cause protections against removal by the president, at least for independent agencies. There it was the FTC, and these are multi-member groups. And what the court reasoned is that if you've got a lot of people in these independent agency type arrangements, they're performing functions that are different than just an executive branch official like the Attorney General or the Secretary of HHS. They're sort of hybrid features of adjudication and lawmaking, and they need that sort of independence. Why? Because the court said so. This is like all big, heavy constitutional cases. It's just they sort of make it up as they go. So the question is, should that apply when it's just a single member? I think that because I think the conventional wisdom is this is unconstitutional. The president needs to be able to remove these people at will, but we'll see. There will presumably be a battle about that. The government, for its part, has always defended the constitutionality of these agencies, but it's a real shocker that this administration changed its position and said, no, these groups are unconstitutionally constituted after all. But the government has this, and it's just got to love this from the government. The government's view is, yeah, it's unconstitutional, but so what? You can just sever and make them removable for cause. So now the president can fire these people, and that's a perfectly rational way of resolving this. The people who are subject to these regulations have a different view, and so the question presented in a series of, I guess, 3 cases. There are 2 cases in the Court of Appeals involving the constitutionality of the CFPB. One is the one that's quickly in time is the Ninth Circuit case, and the government has agreed to cert being granted, and that's called the Sala case. There is also a case arising out of the Fifth Circuit. The Fifth Circuit just held that the FHFA was unconstitutional, and that's behind it in time. And then just out of the blue yesterday, All American Check Cashing filed a cert petition in an unusual posture called cert before judgment. There's been no decision by the Fifth Circuit. It also involves the CFPB, and this is a case filed by Ted Olson and Helgi Walker out of Gibson Dunn. The three of these people are trying to argue in front of the court about which case the court should take, because obviously there's this great uncertainty about whether these groups are constitutionally set up, and if not, does it matter? And I think that the 3 questions sort of does it matter is, do these regulated entities now get to go before the same guy or gal and get a whole do-over? Does only the party who brought the challenge get the benefit? Or can the government just retroactively correct it? And now that the newly, somebody who's got the fireable at will status, can he or she just go back and say, yeah, I'll nunc-pro-tunc this or retroactively say it's okay? The argument on the other side, of course, is, wait a minute, I had a structural right to appear before official who was acting in capacity of where he knew or she knew that they could be fired at will by the president. These are issues that I'm not sure the average American will be able to process, but they are huge issues for the justices and huge issues for regulated parties who feel like that these sort of separation of powers issues provide strong structural guarantees to protect, for accountability and just making sure that I guess political accountability is the best way to put it. So there was one other case on the docket that I am counsel of record for, so I won't talk about it, but that's Atlantic Richfield versus Christian, which is a CERCLA case that Washington Legal Foundation filed an amazing brief in. And that's another interesting case of statutory construction. It's an environmental case, but it also has important questions about preemption. So I encourage you all to read Washington Legal Foundation's amicus brief. I don't have any more, but I'm happy to talk about questions or themes.
Thank you very much, Lisa. Thank you very much, Pratik. There's a lot of stuff in here to explore, not just the cases that were analyzed this morning, but some of the themes that were analyzed. Particularly, if I take the 2 that both Lisa and Pratik focused on a bit, the stare decisis question, and then I call it maybe the appointments power question, but it's really the separation of powers. And I might just hypothetically say, in many ways, these 2 are at the heart of how people see the functioning of government and whether power can be restrained or whether power is unlimited or who exercises authority, and it ties in as well to the Chevron and deference to agency decision-making. I think there's some big themes running there that a lot of people who are sort of in the legal, political class world are spending a lot of time on, because they drive political trends and they drive view of the exercise of power in government. So if each of you would just comment perhaps a little bit further on stare decisis and how you see that playing out, and maybe what are the presumed standards that are applied by, whether it's Kagan or Thomas or whoever. And I will note on the side, there's been a lot of thought given to this. Some studies have been done, and I think people have sort of largely concluded that in stare decisis, it really comes down to, well, precedent should be followed except when it should be reversed. So, but there have to be some underlying, well, there doesn't have to be, some underlying principles maybe that the justices are looking to, because the stare decisis is obviously an issue in the confirmation process, and it's an issue in terms of stability of court and how people respond and react to the rule of law. And then secondly, the appointments clause, consequences, the CFPB, a whole range of things that you've raised. I mean, there's just a lot of intensity out there. And that ties into and drives into sort of Chevron and where can the court, will the court, should the court begin to cut back on some of the delegation latitude and the deference to administrative agencies. So if each of you would just take a few minutes and share your thoughts about those things, it'd be terrific. And you're welcome to stand up here, or maybe better, are you want to stay? That's fine.
That would be great if we could sit. I mean, I can start off on at least the stare decisis question. I think, look, this is, I mean, stare decisis is a nonpartisan doctrine, right? I mean, it's just a doctrine. And you asked about, are there factors? Of course there are factors. You look at Casey, and I don't remember off the top of my head what they are, but you look at things like, is it a constitutional versus statutory case? Have parties relied on it? How entrenched it is in the law, and all of those sort of things. But I think maybe as much as any other doctrine, this is one that's pretty malleable. And this is one that is embraced by conservatives and liberals, kind of depending on the era that we're in, right? When the court is changing rapidly in terms of composition and ideology in one direction, the other side is naturally going to gravitate towards stare decisis, right? Stare decisis is a doctrine that is about reliance and all those things, but it's also a doctrine about institutional credibility. And I think when the court changes in an ideological fashion, more conservative or more liberal in either direction, naturally the side that is in the minority is going to gravitate towards stare decisis as a bulwark against rapid change in doctrine that both leads to outcomes that they disagree with, but also, in their view, would damage the institutional credibility of the court. So I think you saw that it started to play out even before last term, right? I can't remember the name of the case, but the union fees case, Janus, right, where Justice Kagan is like, come on, essentially, the conservatives played a role in setting up a case that was designed to knock down the union fees precedent before that, and there was a series of cases that led to that, and said, that's not the right way to go about treating our precedent, and obviously intensified in last term, and it became quite overt with the justices in concurring and dissenting opinions, talking a lot about stare decisis and how much it should matter, and obviously, as both Lisa and I had talked about, Justice Kagan and Justice Breyer in particular, kind of giving staunch defenses of stare decisis, kind of odes to stare decisis, and then on the other extreme, Justice Thomas and Justice Gorsuch saying, look, this is just a cover for not overruling cases that are wrong, and so I think that's only going to increase in the terms ago, and I think really it's going to be the Chief Justice. You asked a little bit about admin law in your question. And, you know, I mean, I think a good example of this is the Kaiser opinion from last term, which we didn't talk about, but I think that was probably maybe the biggest business case of last term. That was the case that dealt with whether the court would overrule our deference. That's the deference that agencies give to the construction of their own regulation, right? Basically, every justice on more conservative justice has written some opinion before that saying it's time to revisit it's an arrogation of agency power, it violates separation of powers, judges should be interpreting the law, not agencies, all of those different things. And yet you have an opinion written by Justice Kagan, joined by the liberals, in which the Chief Justice joins that preserves our. Now, obviously, it cabins it and narrows it and comes up with like a half dozen factors that you have to satisfy before you ever apply our. And then the Chief Justice writes a concurring opinion that basically says, yeah, because of all these factors, our really isn't going to make a difference in hardly any case anymore. But, you know, they avoid overruling the case. So technically, that is a win for stare decisis. But I think the question becomes, and this is something you see a lot in the Chief Justice's, I think, opinions, is kind of his MO, is not overruling a case because of the institutional hit to institutional credibility, but chipping away at a case, right? We saw that in the Voting Rights Act, saw that in the hour, we've seen that in various contexts. And so I think one question is, does stare decisis prevail formally? And then practically and pragmatically, what's left of the precedents, even if stare decisis is adhered to in name. So I'll pause there and let Lisa jump in.
As usual, I'm agreeing with everything Pratik says. One just sort of interesting thing about stare decisis is last term, it takes 4 justices to grant cert in a case. So last term, at least in 4 cases, 4 justices said that they should take cases considering the overruling of precedent. But by the time those cases got decided, the votes were less than 4 to overrule in some of them. It was only like 2, at least in Gamble. And so people tend to get all kind of worked up because a justice keeps calling for a case to be overruled, or a lot of circuit justices call for it, and by the time it gets all briefed and the amici come screaming, some of it kind of, the enthusiasm tends to wane a little bit. My view is not surprisingly going to be somewhat cynical. The court there's a sort of, I guess, physical limitation. They will overrule until it becomes to the point of where it's embarrassing. And then the court won't overrule cases because it's embarrassing. And no one, what Pratik calls institutional legitimacy and respect, it's just unseemly. They get very excited about all these cases doctrinally. I mean, the big cases, I think, the one that most people care about is Roe, and most lawyers care about is Chevron, which is funny because I'm not sure that too many people have heard of Chevron. But those are the cases where I think all this matters. I'm not sure how much attention is on how you look at, Indian treaties, and I forgot what the other one is, I guess the standard for takings. There are some of these issues, those are doctrinally. There is one area of stare decisis that we didn't talk about, and that's when it comes to the economy. There was the internet case Wayfair. There are these cases where I would call them, they're not really about doctrine, they're about a case that just doesn't necessarily make sense in light of the internet or today's economy. And those cases I don't think are ideological at all. They're just trying to figure out, they're ideological in this sense. It's not a right or left issue. The issue is it the court's problem to fix the case, or should it be Congress's problem to just overrule the case? And they sort of go back and forth on whose problem they think it is. But I don't know what will happen with Chevron, and I certainly don't know what will happen with Roe.
Pratik, would you just care to comment on the appointments, power and or separation of powers issues that Lisa had raised?
Yeah, I mean, look, these cases are, we've seen a couple of them. There was the ALJ case, I guess, from a few terms ago. I think before that, it was a little bit different, but the quorum with the NLRB. And I do think that the remedy is kind of the ball game in these, at least from the business community standpoint. I mean, people do get very worked up about the formalism of the separation of powers. Is this a properly constituted body? Can you, only remove for cause or not? I mean, it's hard for me to get as worked up about that sort of thing. I think, you know, obviously political accountability and all of that is very important. I'm not sure at the end of the day that if it was a different administration and different agencies, you'd have the same sort of challenges that you have now. I think this one is going to be particularly sensitive, especially if they take the CFPB case, just because of the nature of that agency and the history of that agency and the people that have led it and all of those sort of things. It gets very riled up. But look, if the court accepted the ultimate constitutional challenge that says the executive should be able to remove for will, as I think it probably will, a majority, you know, but then they say, okay, you can do, as Lisa said, like a non-protunct or whatever, retroactively just say, okay, now you can remove me for will, but I now, you know, reinstate these decisions en masse or something along that, then, you know, the stakes don't become so great, at least for the particular litigants, although, you know, obviously going forward it can have a big impact in changing that. So I think they are going to be a big deal. I think they're going to be very fraught, mostly because of the nature of the agencies that are up there, rather than some deep doctrinal concern about this going forward.
Yeah, and I'll just add, the last ALJs was with the SEC. I think where the challenger's argument gets very real and strong is when these agencies have just a lot of power and they can wreck someone's life or reputation. Then it gets pretty like, you know, then maybe you should have somebody with a lot more accountability deciding whether this business can operate. And so the challengers probably will frame it as this goes to sort of the, you know, the core existence of what that agency was set up to do. The FHFA is a little bit less fraught because it's all financial, but the CFPB, we've got, I think there's payday lenders, there's a bunch of, I forgot who the other, debt collectors. So I'm not sure how compelling their emotional story will be, but maybe they'll find a teddy bear manufacturer.
Are there any questions from the audience or from online, please?
I do have one online question, wondering sort of what the chances are that the court's going to grant the Domino's ADA case. I know Lisa can't comment on that, but I'll see what Pratik's thoughts are on that.
Yeah, look, I think it's a very compelling cert petition. I think it's a very, very compelling amicus brief in the Retail Litigation Center. Look, I think it's an issue, you know, I've long given up the business of trying to predict the cert pool. It's even more unpredictable than trying to guess merits cases, which is itself pretty unpredictable, so I don't know the answer to that. But I think it is a case that has a lot of interest. What's that?
Call for the views.
Right, they could call for the views, that's right. Call for the views of the Solicitor General, which obviously would carry a lot of weight, as it often does in the cert process.
I have another question. It sort of is a piece of what we were talking about in terms of appointments clause, separation of powers, issues of stare decisis. And the question is, you know, sort of the theme is, are the courts becoming more policy makers, policy arbitrators, or are they judging rule of law, more structure of government, et cetera, et cetera? And the two issues that come up in that, one is sort of nationwide injunctions. So is that solely is that become a mechanism really to try to manage federal policy? And secondly, tied to that, are we seeing more stay requests to the court from the Justice Department before a circuit court perhaps has ruled on something? And is that a piece as well of that whole puzzle about how are the courts being used, manipulated, employed to achieve certain kinds of results?
Yeah, want me to go?
Okay.
So on the first one, I mean, the Warren Court was arguably politicized. I don't think the court is more politicized at all. We've always had 5-4 decisions under the Rehnquist Court. I think just the confirmation process has become sort of horrible. And in that sense, just all the attacks and sort of just controversy surrounding them aren't the greatest for the court. But the court functioning, I mean, there are 5-4 decisions, but the court agrees on most everything. So they don't get hot and excited about bankruptcy. There's just lots and lots of cases that they agree on. But when you're talking guns and abortion and race, the court is just going to divide 5-4 unless, I don't know, we have a differently constituted court. The other question was super fun. What was it? The nationwide injunctions. I don't think anyone's going to defend nationwide injunctions except maybe Judge Tiger. I just think that they're going. There's just lots of problems with them. They deprive the other circuits of a chance to weigh in. They deprive the executive branch of its day in court to try to argue the case in different circuits. But there's something a little bit unseemly about one district court sort of extraterritorially reaching into not only the whole circuit, but throughout the whole country. But you raised another interesting question, and that is about the SG's practice of running to the court now, time and time again. Yeah, it's been historical and extraordinary, but in defense of the SG, he's getting relief. The court is not slapping him down. The court is not saying, please don't do this. So some of this may just be driven by the nationwide injunction phenomenon that, as a practical matter, at least like in the census case, the SG had no choice. I mean, they needed to get early resolution. And so I think that's also happening on the immigration context. But it's been a lot. It's transgender, it's immigration, it's census. It's been so many. I don't think the court's going to tire unless the SG overreaches. And I just don't think the SG has done that, even though it's definitely... Some people have been criticizing it because it has been so many of them.
Yeah, I mean, look, I don't think the court, I tend to think the court prefers not to have these sort of cases. I think if it had its druthers, it would have a docket that is much less filled with these sort of emergency stay cases, which forces it to do things it doesn't like to do, like evaluate the merits of a case, at least in a preliminary way without having percolation in the lower courts, pronounce on sensitive political policies. I think the Chief Justice or someone said recently, like, look, if Congress were doing its job, we wouldn't have as many of these sort of cases, and so they're kind of landing on the court's docket, and parties are looking to the courts to clean up things that normally should fall within Congress's bailiwick. I think the court does approach things very differently than Congress or any other body. I think they do approach it like judges, but these are cases that often don't lend themselves to the normal sort of things that in the vast majority of the cases the justices can come to some agreement on. I've been personally shocked that the court hasn't pushed back on the SG's practice of running there. Look, I realize that there are an unprecedented number of nationwide injunctions and that some of them are certainly can be problematic and overreaching. I don't think all of them are, though. I mean, I think in a typical APA case, if a court renders an agency rule invalid, normally that rule is invalid across the country. I don't view that as some, shocking change in how courts operate. I view that as that's what the judge is doing, and that the agency, once a rule has been declared invalid, can't enforce it. But obviously, I completely agree with Lisa that, look, if I'm the Solicitor General and I'm winning, maybe not completely, but getting at least partial relief, virtually every time I go up there, whether it's cert before judgment or an emergency stay, then of course I'm going to keep doing it because I've been successful. But other than Justice Sotomayor, I think maybe Ginsburg joined her in one of the recent ones, not even Justice Breyer or Justice Kagan, at least to my awareness, has called out the SG on that. I mean, the one data point that I thought might have sparked that, and this was early on, you may recall the ACLU petition with the abortion case out of the D.C. Circuit, where the court, the D.C. Circuit ruled that I think it was a minor held in immigration detention could have a abortion, and then the SG's office said we had reached some agreement with the ACLU that they would wait to do that until the sought an emergency stay, and yet she had the abortion, and then the SG not only filed a cert petition after the case had clearly been mooted, but then asked for sanctions against the ACLU. And yet the court didn't seem to admonish the SG's office even there, which seems beyond the nationwide injunction context, maybe an overreach.
Yeah, I'll say one other thing that court watchers have been talking about. I mean, there's sort of the merits docket, which we've been covering, and then what Pratik is talking about with the stays, and Jay is called the shadow docket. And so we're just getting an enormous amount of information coming out of the shadow docket, and it's not just with all these emergency stays. It's in the capital case, the death penalty case, with all the, I mean, it was pretty extraordinary, all the back and forth with all the separate opinions about whether the court should stay or not stay executions, and a lot of sort of the internal working sort of spilling over into the opinions, and the justices sort of unusually sniping at one another. So yeah, you saw the emotions really ratchet up in that part. But just a lot of what we're learning about the court is coming from these cases that aren't going in through the normal course of cert petition and then briefing and then oral argument and then a decision.
Other questions from the floor?
I have a question about nationwide injunctions. You guys kind of talked about some of the problems with them, but is there a case where the court's going to be able to directly get at that issue? I mean, they've been given a few options, or is it something that we're going to have to be looking at the lower courts to kind of get the message?
Well, they have to first rule against the SG on the merits to get to the nationwide injunction case, and that just hasn't happened in the ones that they've teed up, like the travel ban had it teed up as a QP. I think DACA might have it teed up as an underlying QP. I'm not sure about that, but obviously the SG is trying to get it teed up, but if they win on the merits, then it becomes moot.
And the circuit courts have issued various opinions on nationwide injunctions, and to me, it's sort of a misnomer on nationwide injunctions. What Pratik just talked about, if a rule is held to be invalid, does that apply nationwide? Well, it's a Medicare regulation. No, one court can say the regulation's invalid, another circuit could say it is valid. So this is really complicated. In any given context, what you're seeing it is in the immigration context, and so it's all these. They're coming out of the Ninth Circuit.
If you could comment on one other area that sort of relates to structure, power, apportionment, balancing, et cetera. Issues relating to state sovereignty, federalism, maybe preemption comes into that as well. But we've seen there's some cases, the Nick case, the Timms case, I think Atlantic Richfield a little bit. There's areas where the court seems to be saying, states, you can't get out too far in front. So what are you seeing in this area, and are there some trends, or is it just sort of case by case all over the board?
There is a case on the court's docket, Allen versus Cooper. It's a copyright case, whether
North Carolina.
Is it North Carolina?
Maybe.
Oh, yeah, it might have been. It's really an interesting case. Somebody filmed I think it is North Carolina, a shipwreck, and they licensed it to Nautilus, and I think North Carolina just put the whole film up on its website. And I don't think the person who made the film underwater was too happy. And Congress does have a statute making states liable for copyright violations, and there's the Supreme Court case saying you can't do that. You can't override state sovereignty. But then there's another case that said, well, maybe you could do it in the bankruptcy, or you can do it in the bankruptcy context. So yeah, they're going to be fighting about state sovereignty and Congress's power to abrogate it in that case, in the copyright context. So it's just a fun case, but it's weird to talk about. The doctrine is based on, is Congress sort of appropriately acting within its power to remedy constitutional violations, and it's just weird to be talking about this with a copyright case as opposed to, race or disability. So
yeah, I mean, I think that's all right, all correct and agree. I mean, this was really a big project of you alluded to the Rehnquist Court, right? I mean, we had all those Section 5 of the 14th Amendment. Does it abrogate 11th Amendment immunity or not? Like you said, all these sort of discrimination cases would get to the court. I mean, that project, I think, is largely done. I mean, this is kind of loose ends territory when we're talking about this sort of stuff. I mean, you still have state sovereignty coming up, obviously, in the context that you mentioned. Just last term, that was one of the ones where they did overturn precedent, talking about stare decisis. That was whether states have sovereign immunity in the courts of other states.
Right.
That was Hyatt, where, prior,
How about the
and
Montana
overruling that.
EPA dispute, whether Montana can override the EPA in cleanup issues? Would this issue come up at all in the context of what we're seeing with the administration seeking to overlay California's regulatory stuff in the auto industry, and if California continues to push forward, where does that come down and how does that fall?
That's
That's
really
going to be
good
a fun
question.
one.
Yeah,
That's going to be a
gonna
really fun one to look
Right,
at.
right.
Especially, I think what will also impact it is what industry says about that issue. I know that sounds weird, but I do think what industry thinks is very important.
Yeah, and you have all these, cross currents, right? Usually it's a more conservatives adopting the federalism mantle, but when it comes to kind of that sort of question, obviously they're on the EPA, at least the administration is kind of all EPA, and then I think the big question, do the conservatives think of this as a traditional federalism case, in which case, good for California, or do they think of, and industry is on their side, so it's pro-industry and for California, or do they think of this as kind of a, this is kind of a federal power case, and so,
Just one final question for me. Just going back to your opening comments, Pratik, if we look at the citizenship case, APA and Justice Roberts' opinion, do you see that as sort of a one-off? Is this a peacekeeping effort by the chief? Does this suggest that really we look for motives rather than actions and results in judging cases? What do you have any sort of lore about that? How you see it?
Yeah, my thought. I think it is pretty much a one-off kind of situation, right? You don't have the justices calling out cabinet secretaries as essentially lying, right? Contrived, to use the Chief Justice's way. I think it's kind of one off. And even the Chief Justice went out of his way to say, look, the district court probably jumped the gun on ordering this extra record discovery, but now that we have it, we're going to call a spade a spade. So I think it is more of a one-off. I give one caveat on that, though. A one-off after this administration, maybe. There are cases which may come about, just given how this administration has operated, where, it's called, even the DACA case this term, right? There's, questions about, where these, there's a contemporaneous rationale and then the after-the-fact rationales, and the government kind of embracing the after-the-fact rationale, so it's kind of counter to, it is inviting to go beyond the contemporaneous record. So I think there will be references to it, and it may get some play. I don't think the court is going to be aggressive in invoking it. Now, lower courts, however, I think may take great license with that language, especially the quote where the Chief Justice quoted Justice Friendly, for whom he clerked, say that, we don't have to check common sense at the door, something like, judges don't have to operate with a naivete that ordinary citizens are free from, something like that. And so I think lower courts will run with it. I don't think the Supreme Court will.
Yeah, I agree. I also think we're now heading into some uncharted territory. People are talking about motives and improper motives of Congress now in terms of subpoenas and trying to get the president's tax return. So, yeah, it's a one-off case, but we're in a period now where we may have a few one-off cases. But no, generally, you're not supposed to look at the motives. So.
Any other questions online or in the audience here? Well, Lisa, Pratik, thank you both very much. We appreciate your insights, we appreciate your participation, and WLF is grateful for the insights and your time this morning. Thank you very much, and thank you all for participating.
Well, I learned a ton from you.
What's that?